Thank you so much, Anna, and thank you everybody for being here. We're going to talk today about confidentiality and information sharing, because those are really two sides of the same coin in an elder abuse enhanced MDT. So I'll start by introducing myself. I am Alicia Aiken, and I am an attorney. I am based in Chicago, but I work nationally. I have an organization called the Danu Center for Strategic Advocacy, and we do a wide variety of strategic assistance to mission-based organizations. And one of our major projects is Confidentiality Institute, and that's where I support helping professionals working with violence survivors to think about how does information get managed appropriately. And then I spend a lot of time helping interdisciplinary groups to work together. And so that's what we're going to work on today. This presentation is made possible by the Office of for Victims of Crime. And just remember that what I say is what I think, and they're not necessarily saying they think the same thing I do. And I am happy to take responsibility for the things that come out of my mouth. So what are our goals for this session? I think the goals are to help teams identify the questions that need to get answered locally. And that step is very important. I know a lot of times folks sign up for a session like this and they want me to give them the answers. And there's really two reasons not to do that. One is because you are unique. What you are and where you are is going to be different than what and where someone else is. So it would be, frankly, out of line for me to roll into town and have some kind of one size fits all. The value that I can give you is to help you learn the questions that need to get answered. And then I think you're going to be able to answer them and you're going to be able to move forward in a better way. We're going to spend some time highlighting some information sharing norms for professionals who are commonly on enhanced MDTs. And that, I think that is important. And that is a little more knowledge transfer than discussion. But I think highlighting how other professionals who you know and like and respect, but come from a different tradition, are going to approach information sharing in a different way for very grounded, good reasons. And part of collaborating together is learning each other. And so it's just going to be the tip of the iceberg of showing you what differences very commonly come up so that you can begin to see the importance of understanding each other. And that leads us to understanding how information norms impact the way the group works together. So I very much want you to ask questions if you have them. That means I'm going to invite you to, you can put questions in the chat anytime they come to you. I am going to keep an eye on the chat. And if I know I'm going to answer something in the presentation, I'll hold it. But if something really should be clarified right away, I'll take it right away. If you'd prefer to talk to me rather than use the chat, then just if you can raise your hand, and then that allows me to find a pause and call on you. Okay, so we're talking about working in groups, and I actually think the puzzle metaphor is a very good one for these groups. There's a lot of different pieces. They are shaped differently. And part of our job is to figure out how are they going to fit together correctly, and we can't force what we can't force. When I do this work, and I've been doing this national technical assistance for a little over 10 years, people will often contact me and say, I have a thing I want to share, can I? Or somebody's refusing to share, why won't they? Or tell me what the rules are so I don't break them. And I understand why people ask those questions, but I want you to reframe, because the real answer is usually it depends, which is the thing that lawyers say that annoys everyone, and I understand why. But the answer to what you can or can't do, or what you should or shouldn't do, depends on who you are, on who your group is, on what your goals are. And so what we're going to really focus on today is thinking about the why of sharing information, and maybe a little bit of the when of sharing information with your MDT. and supporting you to get grounded in who both you are individually and who your group is and what your goals are. Then we're going to do another session next week, and that one's going to be more about the how of sharing information, with a special focus on the how of using technology around sharing information. All right, so where I would like to see people start is to have the team reach consensus. And consensus about what? Well, I think there's 5 major things. What is the purpose of the team? Like, why does this group come together? For the participants who are on the team, first of all, understanding who they are, and then what is their role on the team? Not just their role in the community. We know why folks are important in the community, but what is their role being here on this team, whatever here looks like for you? What is the law that applies to your team? And what is the law that applies to each team member? And we will send you a PDF of these slides, so you'll be able to see them. So right now, just kind of focus in on, frankly, challenging me, asking me questions, making sure what I'm saying makes sense. And then you'll be able to have the slides as a reference if you want to go back and say, hey, I went to this great presentation and she said we should do, oh gosh, what were the 5 things? You'll have the slides to help you remember that. And then the final thing the team needs consensus about are what are the norms and expectations around information sharing. I use this word consensus on purpose, right? Consensus is a common understanding of what is appropriate for your work together. It is a thing that everybody on the team can live with. Actually, in a lot of ways, the best description of consensus is we've reached a place that we all, A, understand what it is, and B, can live with it. Even if, truthfully, if I was the benevolent dictator, I would order us to do it a different way, but I'm not, because I am in a collaborative group. So a lot of this is foundational. If your group is designed to honor and respect both elders who have experienced exploitation and harm and abuse, and also to honor and respect the expertise and the value of all the different members of your team, then your team really has to lead from this idea of, hey, we all have to be on board. And if we're not all on board, then this isn't going to work. It's not going to be a collaboration. It's just going to be a top-down, one profession is ordering other professions to do something. And frankly, in my experience, it's not going to get you where you want to be. So looking at question number 1, what is the purpose of the team? These are some of the common purposes that I see in the community. That some folks say we come together to name and identify individual complex cases and to really problem solve them. Some folks say that the purpose of their team is systems improvement. It's not so much about individual elders. It's about we have our systems are not meeting elders' needs and we want to make the systems better. Some teams' purpose is to just facilitate referrals and getting elders' needs met, whether it's a complex case or not. Some teams are very much about increasing the success of prosecution. So I'm going to ask you a poll question. I'd like you to tell us, to share what is the purpose of your team, and you are allowed to answer more than one. So Zoom uses this phrase multiple choice to mean you can choose multiple options. What's the purpose of your team? Okay, I think we are close. Oh, thank you. Okay, so let's talk about this for a minute. I really appreciate the person who was honest and said, I'm not completely certain. And that's okay. And that's actually fairly common. I see that a lot. So a lot of times teams are generated by somebody in maybe a county commission Or even a state legislature decides it would be a good idea to have a team. And so they pass a resolution, or they provide funding, or somebody goes out and gets grant money and says, okay, we're funded, so we're going to meet. I've genuinely had folks would say, when I ask them, why do you meet? They're like, because we're paid to. And so naming that and knowing that is important to moving forward and saying, okay, well, let's spend some time naming. So a couple of you answered increasing prosecution as a goal. Most of you answered facilitating referrals and meeting needs. Most of you answered reviewing individual complex cases, and about half of you answered systems improvement. So that's really helpful for me to know who's here. And again, for you to do an inventory. So I would recommend going back to your group and double checking your understanding to see if the rest of the group actually has the same, again, consensus agreed understanding of what your goals are, because that will help a lot down the line as you're deciding what's appropriate or not appropriate to share. Give me one moment. There's like too many windows open on my screen and I have to adjust them. All right, so some people will say to me, but it's all of them. And I suppose a group could come together and reach consensus that you want to do all the things, but if you want to do all the things, some of them are in conflict to each other. So for instance, this is just an example. I'm not accusing anyone of anything, but it is an example that in some communities, the way that prosecution is handled may actually be causing harm to elders, or it's causing harm to some elders, right? Because the community that they come from, the experience of engaging with criminal justice, the impacts of criminal justice on the broader community, the willing or interest versus coercion to participate in prosecution. All of those things can be very complicated. And so if you say, we're going to do all the things, how do you simultaneously increase prosecution, but also reform prosecution and meet the needs of individuals who might be saying to you, prosecution doesn't help me? So that's why sometimes all the things can have what I might call time bombs, like little buried problems that are going to come up in an individual case, and naming whether or not you want to narrow what you're trying to achieve, or even just naming the conflict. It's okay to have different values that are in tension with each other, and to be sometimes forced to think through, two things we deeply care about are in tension. How do we make a purposeful decision about which one is going to win out in this moment? And then how do we reflect on that decision afterwards? You may also, if you have multiple purposes to your meeting, to your group, you might have some meetings that are for one purpose and some meetings that are for another, right? And then that changes who attends which meetings. Now, you might choose to have some meetings, and meetings sounds very formal, but sometimes just interactions or information sharing that is about case coordination, and a different meeting that's about supporting prosecution. And if everybody can check that you're muted, so we don't have any issues with interference. Thank you. So think about whether or not there are different meetings that have different purpose. And actually, the best example I've seen of this recently is if anybody has seen the movie Being the Ricardos, the Lucille Ball and Desi Arnaz film recently. It is very interesting to watch that film, how the character of Desi Arnaz, and I think this is true to who he really was, will make choices in the moment about who is in the room for which discussion. If you watch that film, he is constantly making choices. You get to be here, but I'm going to ask the three of you to leave. And like powerful people, he would say, no, I'm not having this discussion in front of you yet. He didn't have any laws or rules that applied to it. He was just making strategic judgment calls. Because his wife was like literally the most important television star in the world, he could say to people, you have to leave the room, and they would do it. You may have to build a different source of power in your community groups to decide who is in or not in the room. But there is nothing wrong with saying, for this meeting, the appropriate people to be here are these folks and other folks who we value and respect and very much need here for other purposes, it's not appropriate for them to be here now because of the nature of the conversation that we plan to have. So always remembering the purpose and staying grounded in it. So that might mean that you actually have somebody, whoever is maybe the project director or the meeting leaders, has that purpose either written down or handy to be remembered as you are having discussions or interactions or meetings, and folks might forget, and that's normal and reasonable. We all need touchstones that can reconnect us to our purposes sometime. If someone else chose the purpose, if you were invited to join your enhanced MDT and it pre-existed the grant and it was created by, for instance, a county commission, then, and that commission named a purpose, then you need to honor that and know what it is, right? Go find out. And maybe sometimes they'll say, oh, we don't know what you're supposed to do. We just thought if we put all you smart people in a room, good things would happen. And you could say, well, thank you for the trust. And then your group actually knows it has some work to do. When new people join, you're going to have turnover. In fact, if you have turnover, that's a sign of the longevity and the power of your MDT, because just individual people leaving doesn't cause it to die. So that is a good thing, but you have to have a plan. A plan for onboarding is what we would call it with a new employee, but have some kind of a plan for when new people come. How are they going to understand the purpose and the culture of your group? Whether it's documents that they read, whether there are things that you say at meetings that can ground all of you each time you meet. And so you're going to teach the new people to do that too. Whatever it might be, you have to have a plan, because again, we know sometimes people come to the meeting because they joined an organization and their boss said the MDT meets the fourth Wednesday of the month at noon. Go to it, but they don't actually know why they're there. And as time goes by, even if you have no turnover, you have all the same people, always reconnecting to why you're there and what you're doing. It's almost like renewing your vows, because it can be so easy to forget. Local politics and relationships, cultural hierarchies, the way that we make up rules about who has privilege and who does not have privilege, all of those things will affect your group. And so you're going to need to have systems in place to reconnect to your consensus purpose for what the group is doing and how it's going to function and why. Because if you don't do that, you're going to end up in a tug of war. And I will be honest, most of the time when I get calls from folks will say, I have a confidentiality question. Can I share this? Can't I share this? They think they're calling me and that a lawyer is going to tell them a rule and then they'll be able to win the tug of war. Usually what's really going on is there is some kind of a relationship breakdown. And the fight over information is just the place that is manifesting. And it's really about a group process issue. And nobody is happy and nobody is achieving any purpose except making each other feel frustrated. So that is not what we want. That's not a good use of anybody's time. A couple of things that I'd like groups to stay aware of as you are making these decisions about your consensus of what your group's purpose is. And the reason I'm spending so much time on this is because that will begin to define what is appropriate information sharing. Right? So the rules are going to differ depending on what you're doing. So for one example, if you decide, look, our goal is to support prosecution. That is kind of what we're here for, to make prosecution a better experience for Elder, to make prosecutions more successful, more appropriate, more tethered to justice. All of those are good purposes. If you choose that as your group's purpose, then if the prosecutor is in the room and law enforcement is in the room, whatever information they are exposed to, if they are going to go forward with a charge, then they may have to disclose what is shared in your group. Because and I'll talk about that why in a minute, but that is something to be really aware of. So if you have a group that's like, well, one of our goals is prosecution, but another is to look at hard, complex cases where the needs are really about social service needs, mental health needs, access to housing needs, maybe you should have a separate meeting that the prosecutor and law enforcement is not at, because things that come out in that reviewing complex case may be disclosures that actually undermine prosecution. And if you shield those government law enforcement folks from the information, then it's not going to come out in the prosecution. Oops, I think I might have gone one too forward. I did. So another thing that comes up is this a healthcare purpose? So as you know, healthcare providers, if they are billing for their services, whether it's Medicaid or a private insurer, and they're using electronic billing, they are covered by HIPAA. We could do a whole session just on HIPAA. I'm not going to try to do that today, but I will say that there's a high level of misunderstanding about HIPAA in the US. It is not a generalized privacy rule. It's not a generalized all healthcare privacy rule. It applies to most healthcare providers, but not all of them. And what HIPAA really does more than anything else is it puts the healthcare providers in charge of deciding how to share information with other healthcare providers for the purpose of furthering healthcare. And that's important because if the purpose of your group is to do something that is genuinely identified as provision of healthcare, that may free up the HIPAA covered providers to share some information, but it may also put some duties on the group to follow certain HIPAA rules. And if you have a document somewhere that has named the purpose of your group as increasing prosecution, then that kind of creates a situation where your healthcare providers can't call it provision of healthcare, because those are not the same thing, they're different, and that wouldn't be intellectually honest, and it kind of puts everybody in a precarious position. So if again, people come to me and they're like, tell us the law. This is one place where what I'm going to tell you is what the law is for your group and for the individuals in your group is going to vary based on some of the decisions you make about who your group is and what your group is doing. So that leads us to the second question, which is who are the participants on your team? And paying attention to who they are is extraordinarily important. So the first off is who should be here. And again, the reason this is the second question, not the first one, is because who should be here is somewhat related to what are you trying to achieve. And having different meetings for different purposes may define who should be in the room on that day. So who should be here and who should be here today? And if we think a professional should be here, we have to answer the question, well, why? What do we think that they are bringing to the table? What do they think that they are contributing or doing for the group? And listed on the slide are some of the possible things that someone might be doing, right? They might just be bringing their expertise. So some groups have a gerontologist on the team who isn't directly serving any of the elders who may be currently experiencing harm. But the gerontologist is an expert in cognitive issues for elders, in understanding medical needs for elders, and thinking about how they may interact with systems, right? So they're just bringing their expertise. Some people might be on the group because they are bringing information about individual elders. And some people might be there because they serve a function of taking information to individuals, such as to individual elders. Sometimes somebody might be there because they're like, look, I'm trying to learn how this all works and how our systems could be better. Or I'm here because I am trying to make change. I'm actually advocating for something. And again, an individual person can be there for more than one reason, but coming in with an awareness of why are you here and what is your purpose, and does everyone else have an understanding of what that is? So here's a good example that comes up a lot is victim service providers, domestic violence advocates, sexual assault advocates, crime victim advocates. And right now I'm talking about community-based advocates who work most of the time in nonprofits. Once in a while they work for a county, but they do not work for law enforcement. Folks who work for law enforcement, whether you are, I don't care if you're called an advocate, if you work for law enforcement or a prosecutor's office, you are part of that team. So right now, the example I'm talking about is victim service providers who work for community-based nonprofit. There is a real habit when leaders form multidisciplinary teams of recognizing that advocates are knowledgeable and important and putting them on a team, but never having a clear sense of why they're there and what is expected of them. So sometimes what will happen is that victim service provider is pressured to answer questions, individually identifying questions about the elders that they serve, and that may not be lawful or appropriate for them. And so sometimes I get called in on those conversations and I will say, because of confidentiality, that's not an appropriate role. And people will say, well, then why are they here? Right? And because there's lots of reasons why you would want an advocate on your enhanced MDT team, even while they are following their confidentiality rules. Lots and lots of reasons you want that expertise and that knowledge and that vision and that view of what is possible. But you have to value that stuff and you have to have a discussion, because otherwise you just get somebody who is already not paid enough for the really difficult and important work they do, getting told that they're just, they don't play nice with the team because they're following the law. And we do not want that to happen to anyone on your team. Before I get to number 3, I'm just going to pause. Does anybody have a question that you want to ask? This is like an open offer to either post something in the chat or to unmute yourself and ask a question. See, in person, I can make eye contact with y'all.
I'm not seeing anything in the chat so far.
Okay.
I will just give a quick reminder that we have 2 tribal communities on the call, and so just a heads up that that's included as well.
Absolutely, absolutely. Yeah, and these principles of how are we going to work together? Why are we coming together? What are the rules around our work together are absolutely applicable, right? And all the unspoken hierarchical local politics, local relationship dynamics can play in communities if we don't talk about them and address them head on. All right, so question number 3 that your team needs to take a look at, which is what's the law for the team? And that is very much going to vary depending on what jurisdiction you're in. Was your team created by a statute? Sometimes that is true. And again, it might be county, it might be a city, it might be a state. So just because your team is getting federal funding, that's great, but that doesn't mean that that funding necessarily, that's not law that creates your team in the same way. So so if your team was created by a statute, that statute is going to give you some rules about how your team should function. And it might have rules related to confidentiality, meaning that information shared by the team or within the team has some level of protection and is not supposed to be further disclosed. Your statute might have rules about that. Your statute might have rules about whether an outsider is allowed to subpoena the information that you shared in your team. And your statute might have rules about exceptions to confidentiality or mandatory disclosures that your team is supposed to make. Some statutes will say, this person who is a confidential professional who normally wouldn't share information is actually allowed to, or sometimes it might say required to share with this multidisciplinary team. And if it says that, then you can follow the law. But it varies a lot from state to state, whether there's any instruction, and if there is instruction, what it is. And in a moment, I'll show you a great guide that has been put together by the Department of Justice to try to find your local statute. It covers state statutes. It does not have any tribal law on it. So here's how I want you to think about confidentiality. And this is a word that gets thrown around a lot, but actually different people mean very different things about it. But I want to talk about confidentiality in a collaboration. So what I see often is folks will say, well, we have a rule that says that everything that we discuss in our group is confidential. And so for that reason, everyone in our group is allowed to speak freely. That's actually not correct, and it's kind of the wrong way to analyze the situation. So there's really two steps when it comes to confidentiality and what can a professional in a collaboration say. The first step is I want you to think about Vegas, right? So some groups will say to me, well, we essentially have Vegas rules. What happens in the group stays in the group. And I actually, this is not related, but I think it's funny that Vegas, the Vegas Chamber of Commerce, for a while, you may remember they had a Bring Your Family to Vegas ad campaign, and apparently it didn't cause one single extra person to go to Vegas. But as soon as they said what happens in Vegas stays in Vegas, like everybody started going. So that feeling that you can speak freely and it won't go anywhere does tend to make people feel more comfortable sharing, right? And so it may be very appropriate to have that kind of rule for your group. Although, remember, some people in your group may have laws that apply to them that mean they can't agree to that. And we'll talk about that in a second. But that question of whether something you share in the group, what happens in Vegas stays in Vegas, doesn't actually answer the question for you about what are you allowed to bring to Vegas. So you need to think about it in a two-step thing. Am I, as a professional, do I have the power to decide whether to share with this group? Once I share with the group, how safe and protected do I think it will be? And so if groups have strong confidentiality practices, if I have the power to decide, then it will influence my decision whether it's a good idea to share or not. But nothing about your group's confidentiality changes the rules that I walk into the room with. So I'm going to overstretch the Vegas metaphor, but like if my mom told me I can't borrow her boots, I can't take the boots to Vegas. It doesn't matter if Vegas says they won't tell her. I still had a rule that said I couldn't bring the boots. So you got to think about your information sharing rules in a similar way. And so just being put on a group, like if you have a state statute that says advocates, doctors, prosecutors, police officers, adult protective services will all be on this group, but that's all it says. It doesn't actually change your rules about what you're allowed to bring to the group or not bring to the group. It has to explicitly say that. And I raise that because that has happened many times when folks say, oh, there's a law that says we have to share with this MDT. And when we look up the law together, all the law says is we are on the MDT. But then people made an assumption, they jumped to assume that being on the MDT means I am required to say every piece of information that I know, and that's not an accurate leap, unless the statute says so. So this is, and again, we're going to send you this a PDF of the slides. So this is the link to a 2019 statute compilation that was done by the Department of Justice that I found very helpful in getting a kind of lay of the land. Again, and I have a statutory compilation I do for advocate confidentiality, and it is tricky business to keep up with them because most states have legislatures that meet every year, and so things may always be changing. So it's always important to use a resource like that as a starting point. But the gift of the 21st century is anyone can look up a statute in any state or territory using the web. Looking up tribal law can be trickier. Some tribes have posted it in a library online, some have not. If you're in a situation where you are working to figure out what the law is in a tribe, then I think reach out for technical assistance. And we have some experts on tribal law that we can help connect you with. Because the state statutes are a little bit all over the place. Some will say, yes, you're a confidential professional, but you are allowed to share with the MDT team. Others will say everything that the team talks about is confidential. It can't be introduced in court. And some will set rules for how you're supposed to go about, if you're doing an investigation of working on a case, how are you supposed to go about doing that? But here's a really important point, and this is a big source of confusion. MOUs, memoranda of understanding, they're not law. They cannot change the law. So back to the Vegas example. I'm going to Vegas for the weekend. What happens in Vegas stays in Vegas. My mom said I can't borrow her boots. I take them anyways. And she says, why did you take my boots? And I say, well, because they told me that nobody would talk about what happened in Vegas. So I figured it would never get out that I took your boots. And she's like, that doesn't change that I said you can't. Same thing with MOUs. MOUs cannot change the law. If you don't have power to give something away, then you can't agree to give it away in an MOU. They are really they are agreements where you find your consensus. So I was talking earlier about the importance of knowing what your purpose is. Why is everyone there? That's the magic of a really good MOU. How do you build culture when there's turnover? You have a really good MOU that people read and sign on to. So if there is a law that says this information is privileged, this information is confidential, there's really nothing you can sign in an MOU that would change that law or change that ability. And if there's a law that says this information must be reported or must be shared in a criminal case, there's no MOU promise that anybody can sign that will change that. So really being aware of what MOUs can do and can't do and what their role is. Their role is to build culture, but their role is not to change the law. They can't do it. So here's an excellent example. I see this a lot. I see law enforcement folks who are trying to be good partners, sign an MOU that says what happens in Vegas stays in Vegas. Nothing discussed here will be shared anywhere else. And then the law enforcement folks forget to tell everyone else that they actually have a different rule they have to follow. So is somebody on here who knows what a Brady exculpatory disclosure is? Want to take a crack at explaining it to the rest of the group?
I can take a go at it.
Great.
In a domestic violence case, the night of the incident, victim tells cop he hit me and smashed my phone. 2 days later, she will email our office saying, he didn't actually touch me and he never really hurt my phone. I have my phone here with me. We have to task that to our attorneys to see if they can review it to see if that means the case is going to be able to go forward or not.
Okay. And can I ask, Linda, what position do you work in?
I'm administrative and I handle a lot of victim advocacy pieces.
But are you work inside of a
Oh, I'm
law
sorry.
enforcement? Yeah.
Prosecution office, yes.
I'm sorry, what?
A prosecution office.
Right, exactly. Okay, so that is a perfect example of a very practical example of what Brady is. So Brady is a rule, it's a constitutional fairness and due process rule that says anytime the prosecutors or law enforcement, and that's really anybody in those divisions, and it can spread out to more parts of government too. If you have what's called exculpatory evidence, then you have to share it with the criminal defendant and their attorney. What is exculpatory? Besides being fun to say, I encourage you to try it. Exculpatory. It is any information that tends to show that a defendant is not guilty,
swap that your organization
or discredits a prosecution witness, or reduces the seriousness of the offense. So again, this is constitutional. The reason it's called Brady is that's a US Supreme Court case that defined it. In some states, they will use a different term for it. But in the US system, any prosecutor or law enforcement must follow this rule as a fundamental element of due process, which means that they cannot agree to keep information from the criminal defendant. Now, if you are a community-based victim advocate, you don't have a duty to share information with the defendant, right? So what you know, you don't have a duty to call. If an example like Linda gave where somebody says, actually, he didn't take my phone, he didn't hit me, the things I said to the police officer are not correct. A community-based victim advocate is under no duty to make sure a defendant knows about that. But the second they share it with prosecution's under a duty. So that's a perfect example of why survivors might share different things with different people for different purposes. And so that leads us to really having a clear sense of what is the law for each team member. And on a certain level, that is a personal responsibility for folks who are coming to teams to understand where they are coming from. It can be tricky, I'm not gonna lie. It's not always easy to figure out because an elder abuse MDT doesn't always fit neatly into existing rules. Law is kind of very slow to adjust and innovate. Communities are actually much faster at thinking of new ways to address old problems, but it can take the law a while to catch up. So I'm just being honest and realistic that sometimes the law, the thing that I have dedicated my adult life to, is not as helpful as it should be. And so you may be having to make judgment calls. And sometimes that means sitting down with an attorney who is licensed in the place where you are to help you make a judgment call about how your team or how you should move forward as a member of a team. I think some teams will talk about, some individuals, their job responsibility is investigation. So especially if you're in adult protective services, you do investigation as a living. Paying attention to whether or not investigation is what your MDT is doing, or if your MDT is doing something different. Because if you have a law that says you're allowed to share information for investigations, but your MDT purposes are different from that, then don't just make the leap. Well, I'm used to making my own judgment call about what to share, so I'm allowed to share, right? We do have to really sort of check our egos to make sure we're behaving consistent with best practice. Okay. And I got, everybody's like, oh, I wish you could just tell me my law. And I wish it was that simple too. What I can do, because sometimes there are only a half a dozen tops lawyers who nerd out on this stuff as badly as I do in the country. So sometimes you may have a very good local lawyer, whether it's counsel for your county government or your organization, or a pro bono lawyer who's very smart but isn't used to thinking about this issue. I can give technical assistance to your lawyer. And so that means I help your lawyer kind of craft the questions, and then I can say, I've seen it answered this way, I've seen it answered that way. Sometimes I can say, I think in your state it's answered this way, but you're gonna have to double check it and make sure you think I'm right. So I'm available to serve that role, or to give technical assistance to you. We're gonna make sure you have my email address so you can ask. So again, going back to that kind of, what can I even take to Vegas question? You always need to be asking the question, do I have the power to decide whether to share information with this group? And if your answer is yes, then do I think it's helpful to share with this group? And having a clear consensus on the group's purposes and how it will use information will help an individual professional to make that judgment call. And it's that, you know, that clear, accurate MOU helps people say, I do get to make the decision when the decision I want to make is yes. But those are two different questions. So one example of that is attorney confidentiality. So attorneys, sort of like the generic idea of attorney confidentiality is lawyers don't share anything that their clients tell them. That's actually not true. And you can just watch one attorney procedural show and you'll see that it's not true, right? Attorneys are sharing stuff all the time. And in fact, are empowered to speak on behalf of their clients in court, in public, in negotiations. So you might have a civil attorney who participates in your MDT. And let's say the purpose of your MDT is individual review of complex cases. And this is a civil attorney who is a crime victims' rights attorney who is representing the elder or the guardian of the elder, either one. And so that attorney's ethics are, okay, well, I can share what my client tells me to share with the group. That means we have a discussion, the client gives me instructions. Or I can share if in this moment, I think I'm impliedly authorized to share. You don't have to spend too much time with those over-lawyered words. The point of that is, let's just say my client has hired me to help them get a successful prosecution to happen. And the lawyer is in the MDT and there's something the lawyer knows that they're like, if I share this with the prosecutor, I think it will help that goal. A lawyer is allowed to make an on-the-fly judgment call that that is what their client would want them to do. Now, we can have a long conversation about survivor-centered lawyering and what is good practice around information management. And there are also some complexities if you are a Violence Against Women Act or a Victim of Crime Act funded lawyer about whether or not you actually have a higher standard. So if anybody is struggling with that, please reach out for technical assistance because we can talk to you, but that's a whole other topic. We're not going to go down that rabbit hole today. And an attorney might have exceptions where the law actually either says the lawyer gets to make a choice whether to share information to prevent imminent serious physical harm, or in some places lawyers are mandated to make certain kinds of disclosures. But the reason I bring this up is just as an example that the lawyers are allowed to say, do I have the power to share with this group? Well, I do if the law tells me I do, or if my judgment tells me the client would want it. And then based on my understanding of this group, is it a good idea to do this or not? Now, a very different approach to confidentiality is victim services. So community-based victim services, if you're a federally funded program, you are prohibited from disclosing identifying information. And the only time you can share is if you have instructions from the survivor or a survivor's guardian, a court-ordered guardian can give instructions, or if there is a statute or a valid court order that requires it. So remember, I said there's two questions. For an advocate, the first question, do I get to decide whether to share this information? The answer is no. And so you could pressure and manipulate and give good reasons to an advocate all day long, and they still will not have the power to decide whether to share or not. Now, you may want to say, I understand you don't have the power to decide whether to share, but I think you're in communication with this elder. And so I'd like to explain to you what we'd like to know, what we would do with it, how we think it helps. And I'm going to respect that you have a process where you may go back and talk to the elder about what they want to do, and you might get instructions, but that you're not going to be able to tell me that right now. And I respect and honor that, but let me make my best case for why somebody would want to give you permission to talk to me. Did you hear the difference between those two things, right? But knowing that you're not going to get a change while the advocate is alone in a room with you or in a group with you, because they're never going to be able to make that choice without having a conversation with that first. Which brings us to the fifth question, which is thinking about group norms for information exchange, because this is a big deal. Like, who leads, who's in charge, how do you take turns for talking, who sets the agenda? All of these things are going to have an impact on who feels like they have permission to speak, who feels like they're honored in the room, who feels like their goals and their expertise are valued. So these are, I mean, I don't talk about this as a diversity, equity, and inclusion issue, but it is. You have to be paying attention to those things in your group, because you don't want to create a group norm that is hierarchical and grounded in old discredited notions of who's the authority and whose voice is valued. That doesn't really get you anywhere. And that is really not going to get you anywhere in making systems change or doing a better job of serving elders, because so many elders who are being harmed also come from, they're already experiencing some cultural marginalization because they're an elder, and then they also have other experiences of being marginalized. They're going to play into how they live and work with the system. I cannot recommend highly enough NCAL. I didn't prep this. I'm just remembering how fantastic it is, and maybe you guys can put it in the chat. The piece that you did around serving older African Americans who have experienced harm and doing it well. Lisa's shaking her head. You know what I'm talking about. Will you put it in the chat?
I can put that in the chat for you.
Thank you so much, because it's so good. It is.
Yeah,
so
it's
good.
a great. If you all are interested in it at all, feel free to reach out to me via email, because that's still an ongoing project we're working on. I'm going to drop my email in the chat right now.
Okay.
So if you are interested in any way in getting involved with, honestly know of any specific, culturally specific direct service providers who work for communities of color, specifically Black women, that would be super helpful. I know that's very specific, but if you have even any more general than that connection, or have kind of had a professional relationship, send them my way. My email's in the chat.
And also we're going to be dealing, the National Center will be dealing with this issue in webinars over the early summer. So we'll be continuing some of the work that that was begun within calling some of our peers with that. So we're excited about bringing that to fruition here too.
Fantastic. The biggest takeaway I got from the materials that I was looking at is the way that so often when we've come from a traditional mainstream approach to doing the work, as we were talking about, we want people to trust us. We want people to trust us. And the takeaway from this panel of experts and also interviews with older Black women who have experienced violence and harm, the biggest takeaway was, yeah, stop trying to get trust, because that is a thing you may never achieve. Like, we've got hundreds and hundreds and hundreds of years why trust is difficult to give. And if you're working with older Black survivors, they've had lots of opportunities in their life to experience racism and mistreatment by systems, and that is going to factor into how they deal with you. So stop looking for trust and display and express respect. And I think that's a really interesting reframing to say, what if we just talk about respect? If I show respect, if I feel respected, that might lead to trust. It might just lead to a willingness to work together. And sometimes that's enough, right? If that's the most that we're going to be able to achieve. Okay, I'm going to launch another poll. And this is a poll where I really would like you to share with us what tools your enhanced MDT uses to protect confidentiality. And again, you can choose more than one, choose all that apply. And there's several options here. I'm going to be quiet for a moment. I didn't accidentally close the poll, did I?
The things up. Did you get that? No.
I think I accidentally.
Responses.
Yes, I have responses and it says I'm sharing them. Is that right?
Yep.
Okay. Well, I apologize. Anybody who was still reading, I am so sorry. I was trying to send a note to Linda with a very interesting point, and I accidentally closed the poll. I think we've got enough to work with and move forward, and we have 5 minutes left too. All of these might be really valuable for you as your team. I'm not telling you that you have to do any of them. Again, this gets at your purpose of the team. It gets at who's there. I do find it interesting. And again, I closed the poll early, so maybe somebody was going to answer this, but we don't have anybody who said yes to only sharing sensitive or protective information with the members who need it, not the whole group. So that might be an area for assessment to say, is there a place for that where sometimes information only goes to certain folks and not to everybody based on the purpose in sharing it? So thinking about that as a possibility. Really, the intention of this poll is to give you ideas for things that might be a good fit for your group. It is not to suggest that anybody is required or supposed to be doing every single one of these. And as Linda points out, the great comment in the chat that the answer changes when you go back to in-person. You used to have people sign a form at every meeting and shredded documents. Everything is virtual now, which means what? Like maybe people are, if people are being emailed documents and they might be printing them out at home and then they're not, so nobody's in charge of shredding them. It's not so easy to have people physically sign a form if we're all virtual. And we're going to talk next week about some of those questions. How do we think about the ways in which we use technology and when we think about managing information together? Basically respect each other, right? Understand each other, ask questions, take time, assign time in your group to learn each other. And I do think some of our professions are absolutely great about saying, I want to train other professions about violence victims. I want to train them about elders, about crime victims, and that's great and that's important, but spend some time training each other about yourself and then work not to pressure or judge each other for following your ethical norms. Although I will say also, check your ego, like pay attention to the difference between an ethical norm and I don't think I want to do this, so I'm going to say it's a law, right? Sometimes we do have I get some calls sometimes where people are like, they're saying they can't share that with me because of confidentiality. And I was like, yeah, that's not just that's not a confidentiality rule. I think maybe you have some relationship issues. I really like this quote from the California Sexual Assault Response Team Manual, that departments can have different objections, but a shared vision. We're going to have a shared vision that we want to eradicate violence and abuse and exploitation of elders, but our in short-term objectives for how we think we're getting there might be different, and that is okay. I do ask people to think about this question: where does the elder fit in? So is there a way for team members to bring information because the elder, guardian, or caregiver requested it be shared with the team? And is there a mechanism for elders to receive information from the team? That's actually why I think what happens in Vegas stays in Vegas worlds aren't a great idea for these teams, unless you're doing systems reform and the systems players need that kind of privacy to speak freely. But if you're actually working on individual cases and individual elders need information about what's possible, then you wouldn't want to have Vegas rules in your team. We do not recommend asking elders to sign a universal release to share information with everyone on your MDT. The different professionals on your MDT are different from each other. And so you can't make one single decision about, do I want law enforcement, advocacy, legal services, financial, housing, protective agencies to know this stuff about me. It is too much. It's decision overload, frankly. And there's an implied pressure to consent, even if you don't mean to. I want to make sure you know about the techsafety.org website, which is a project of the National Network to End Domestic Violence. Confidentiality Institute partner on it quite a bit. We create lots of confidentiality materials, but also lots of materials about technology, use by organizations, misuse by abusers, and technology evidence as it might be used in court. So this is an incredible resource for you. But I'm also a resource in partnership with National Network to End Domestic Violence. We are the confidentiality and technology TA providers for anyone who is a Violence Against Women Act grantee or is eligible to be a grantee. So you don't have to be getting a grant. And so folks who are participating in this project, even though it's a Victim of Crime Act funded project, you would be eligible for us to give you technical assistance. So we are here. I talked right up to the end. That's not good when I said I was going to take questions. I'm respectful of folks' time. So if anybody needs to go, please do. But I am here and willing to stay here a little bit longer and take any questions that anybody has, either by chat or if you want to unmute yourself and ask. I know nobody wants to be the kid who keeps everybody after the bell. That's bad form on my part.
Well, and keep in mind that we have Lish next week as well.
Yes.
So if you want to come with your questions, next week, she'll be able to address those with you. And, you know, she's just a wealth of knowledge, and,
Thank you.
please make sure you ask her everything you can think of while you've got her in front of you.
Yeah, and please send me an email. And actually, we got a note earlier from Benita that Sack and Fox got disconnected. So I want to make sure, I don't know if they're back or not, but I want to make a special invitation for them to reach out to me. And I'm happy to have as much conversation as you need, answer any questions, talk stuff through. And we are going to be sending out a PDF of the presentation to everyone. Thank you, Benita. I know that a lot of times connectivity in tribal areas can be a huge frustration. So I'm here and I'm available, and I'm happy to set up a call with the folks from Sack and Fox. All right.
Thank you all so much. I'll be sending later this week, I'll send a follow-up email with some more information, a PDF copy of the slide, as well as an evaluation link for you all. And feel free to kind of follow back up with any questions. I hope you have a good rest of your day and your week. Thank you all so much for joining us.
Thank you, everyone. Thank you so much to our sponsors today. Thanks for having me. Thanks for inviting me to the conversation.
Thank you all.
Thank you.